Welcome once again to the Law Professor. In this presentation, we shall be looking at presumption of death. Presumption of death as a fact of irretrievable breakdown of a statutory marriage in Nigeria, a marriage celebrated under the Matrimonial Causes Act of Nigeria, presumption of death. And the understandings that we had gained in the earlier presentations on dissolution of marriage should not be forgotten. These understandings relate to the ground for dissolution of marriage and where we established the fact that irretrievable breakdown of marriage under Section 15.2 of the Matrimonial Causes Act is the major ground for dissolution of statutory marriage in Nigeria. But the facts that will be used to establish that are found under Section 15.2, read together with Section 16 of the MCA. And then we had, in previous videos, looked at some of these facts. So today, we are looking at this element that is called presumption of death. The provision of Section 15.2H of the Matrimonial Causes Act says that irretrievable breakdown of marriage can be satisfied on the fact that the other party to the marriage has been absent from the petitioner for such time and in such circumstances as to provide reasonable grounds for presuming he or she is dead. So the person that is bringing the petition is the person that is available, and the person is alleging that his or her spouse should be presumed dead. Should be presumed dead. So that, and if it is accepted, then the decree of dissolution of marriage is granted on the fact of presumption of death. In the course of the presentation, we shall be looking at the basis for this. Why is this necessary? Why can't you just go on with life if the person cannot be found and move on? Okay. Now, the provision of Section 62A notes that where a petition is based on the presumption of death, prove that for a period of 7 years, immediately preceding the date of the petition, the respondent was continuously absent from the petitioner, and petitioner had no reason to believe that the other party was alive at any time within that period, is sufficient to establish the fact in question, unless it is shown that the other party to the marriage was alive at the time within that period, So within this provision, you have the basic components of this presumption of death as establishing the fact of irretrievable breakdown of marriage. It says that you look at the period of 7 years, a period of 7 years immediately preceding the date of the petition. You are bringing a petition in June 2023, then you count backwards 7 years from that time, okay, immediately preceding. If the person was seen within a period of 10 years, for instance, the person was seen 5 years ago, once in 10 years, and it was 5 years ago, it will not fall within that petition. But if it's within the last 10 years, it was seen 8 years ago, and those 8 years are immediately before the presentation of the petition, then that provision would have been met. It must be a continuously absent period. So it must be continuous. There must be no break in the chain, so to say. If there's any break, he's been absent for 6.5 years, and then he surfaces, you can see him, or somebody hears of him, or is seen on television, and since there's evidence that he's alive after 6.5 years, then the 7-year period is broken, and the time will not continue. You have to start running again if it disappears. The petitioner must have no reason to believe that that other person is alive. If you know that he's alive, but it's just that he refuses to come home, you are not going to bring a petition based on presumption of death. Maybe there's an intermittent phone calls, emails, sightings, and what have you. You know, you cannot bring a petition on that ground. The presumption will therefore be rebutted if you can show by any out of evidence that the other party to the marriage was alive within that period of 7 years. You cannot say because you know that he has established a new home in the US or he's living with somebody else, then the law should presume him dead since he has refused to come back to the marriage. You can bring your petition under other grants, living apart provisions, desertion, and what have you, but not on the basis of presumption of death. There must be in the application of this section 15.2H, the decree of dissolution is made in the form of, the decree is made to say that the marriage is dissolved by reason of presumption of death. And once the marriage is dissolved by the reason of that presumption of death, that marriage is dissolved like any other marriage, even if it surfaces 1 month later. 1 month later. So that is the implication of the law. The petition, for you to come to court and allege that a spouse should be presumed dead, the Matrimonial Causes rules demands that the petitioner state the last date that they have reason to believe that the respondent was alive, and state the circumstances in which you want the court to presume that the person is dead. The fact that you cannot hear from someone for some time may not necessarily mean that the person is dead or should be presumed dead. Perhaps there's a good reason why they have not been heard. Maybe if assuming that somebody is a soldier and is not confirmed dead, maybe there's no way of communicating with, maybe the person was kidnapped, for instance, and has no way of communicating and has been for years. You can't just assume that the person is dead. There must be good reasons, reasonable premise upon which that presumption is based. So the law requires that you give particulars of any inquiries that you have made. What effort did you make? The person has been away. He said he's going for a new job. He left Lagos State and went to Kaduna State. And you cannot hear from the person for the last 5 years. You have made diligent search. You have searched his home, searched everywhere. Everybody has looked for him. You must show efforts. You must demonstrate that there has been sufficient effort and inquiries have been made about him from friends, from employers. Where you would ordinarily, the way you would ordinarily look for someone that is missing. So it is not just a question of coming to court, just sitting down and not doing anything, and then 7 years later say, I want to get a divorce based on the presumption of death. In child and charge, for instance, it's a 1955 case. It's not really a provision that is usually canvassed in court. The court, 16 years absence did not raise the presumption that the wife was dead, because the court said there was no reason for anyone to have heard from her. Of course, don't forget that was 1955, and the society was different. The way communication is very fast today is different from then, and what have you. So it actually depends on the facts of the case. In the matter of Olufunso, a lawyer was presumed dead in Nigeria when he had not been heard from the family, from anybody, in circumstances in which he ordinarily ought to have contacted family members. His father died, his mother died, never surfaced, nothing was heard from him, nobody cited him. If somebody cited him somewhere and say, oh, I saw him in so place, maybe he's in prison, maybe he's living another life with another woman, and refused to respond to any inquiries or call or effort from the other spouse, that cannot be based on presumption of death. It can be based on any other petition or grants of divorce. Now, why would the law want to say we are granting you a divorce based on presumption of death? You see, in those days at common law, it wasn't this. The law evolved. We are in an age of communication where it's quite easy to find and track people these days. In those days, when people marry under the statute, of course, we know even today that it does not allow you to marry any other person. And anyone that's married in the statutory kind of marriage, if they marry another person during the subsistence of their spouse, we know that constitutes bigamy. It's a crime, and that marriage would also be a nullity under the law, based on our understanding of the law of nullity. So when spouses disappeared, in order to protect the staying spouse, sometimes you don't know the reasons why the person cannot be found. If the remaining spouse haven't waited for the reasonable number of years expected by law, assuming the law was not there, and the person remarries after 3 years or 5 years, and then the spouse surfaces. That person at common law was guilty of bigamy, having remarried while he or she was still married to the missing spouse. That was one aspect. Then the new marriage was a nullity under common law once the missing spouse resurfaces. And you know that that creates uncertainty in status. Then any child or children that the staying couple has within the new marriage that they had celebrated before the resurfacing reemergence of their missing spouse became illegitimate. Those children became illegitimate through no fault of theirs. And illegitimacy as a status was very, very detrimental at common law, disinheritance and what have you. So to prevent this kind of a situation, to protect the staying spouse, that was the reason why common law developed this idea of dissolution of marriage based on the presumption of the death of the missing spouse. So once that decree is granted, it protects the staying spouse from suits of bigamy, nullity, illegitimacy status of their children. So that is the essential component of the rule at common law, which has found its way into statute in Nigeria under the Matrimonial Causes Act of Nigeria. So essentially, that is the rule regarding dissolution of marriage based upon the presumption of the death of a missing spouse, which is applied after 7 years. After 7 years. In the next presentation, we shall be looking at some other issues regarding dissolution of marriage. Don't forget to like, share, and subscribe to this channel.